Hello dear students, I welcome you all for today's lecture. So let us begin with it. You cannot make people learn, you can only provide the right conditions for learning to happen. This quote is given by Vince Gauman. To introduce my topic, education is such a dynamic and a progressive process that begins with the birth of an individual and continues till the death. We as a human being learn every day in our lives. It is a pathway that leads us to wisdom, knowledge and enlightenment. It not only helps us in shaping our lives and future individually, rather it helps all of us to create a better society as of a whole in which everyone lives with dignity and respect. Education is a weapon in the hands of the people through which they can bring changes in the society. Keeping this in view, it is very important that quality education is provided to all. An appropriate education system creates a sense of responsibility in the people towards their rights and duties. It brings out actual potential of the individuals and promote optimal utilization of human resources, and to step into this system, elementary education plays a very important role. It is the most crucial stage of whole education system wherein little fresh minds, unaware of their surrounding and the whole system are shaped and nurtured and the foundation of personality and capability are laid. But it is pity that our nation has been unsuccessful in eradicating the menace of illiteracy. However, with the effort of various educationists, scholars, organizations and the judiciary, education has been recognized as a fundamental right with the passage of 86th Constitutional Amendment Act in 2002 by insertion of Article 21A and consequent enactment of the Right to Free and Compulsory Education Act 2009, which is popularly known as RTE Act. With this, India became one of the 135 countries to recognize education as a fundamental right. Constitutional perspective of right to education. The makers of the Constitution were aware of the situation in the nation with regard to education and the immense level of illiteracy that existed among the masses. Keeping the intent to curb this menace in the mind, Article 45 Clause 2 was incorporated in the Constitution under the part of Directive Principles of State Policy. It mandated the government to work in this regard with the stipulated time frame of 10 years. The framers were hopeful that within this time period, illiteracy would be wiped out of this country. But the concerned authorities did not put in effort towards their responsibility and the situation hardly improved. In the case of Mohini Jain versus State of Karnataka, it was contended that right to education is a fundamental right enshrined in Article 21 of the Indian Constitution, which cannot be denied to any person on the basis of high capitation fees. In this case, the Supreme Court held that right to education is implicit in Article 21 and it is illegal to deny admission by charging high capitation fee, and it amounts to infringement of right to life under Article 21. Consequently, it was held that Article 21 includes right to education at all levels as a fundamental right under the Indian Constitution. The matter came up again in case of Unikrishnan versus State of Andhra Pradesh. Here, the Supreme Court particularly held that right to education for the children aged between 6 to 14 years is a fundamental right. The apex court disagreed with the Mohini dictum that said the children of all age groups have this right and specifically mentioned the age group and overruled Mohini's judgment to that extent. Beyond this age, the right to education was subject to the limits of the economic capacity of the state. Even though the judgment was passed and the right was recognized as a fundamental right, still on the practical front, there was no improvement. Consequently, the Parliament passed the Constitution 86th Amendment Act 2002, which made education a fundamental right by inserting Article 21A. in the Indian Constitution. The Article 21 allowed education to fall into the ambit of right to life, and in order to provide actual access to it, Article 21 was inserted. The amendment also substituted the Article 45 Clause 7 and inserted Clause K to Article 51A, that is the fundamental duties, which provides that it shall be duty of every citizen of India who is a parent or a guardian to provide opportunities for education to his child, or as the case may be, ward between the age of 6 and 14 years. So with this amendment, obligation is casted upon the state authorities as well as on the parents with one common object: compulsory education which is free from financial barriers or state inaction. International perspective of right to education. The right to education has its root in many international instruments. The Universal Declaration of Human Rights 1948, Article 26 recognizes right to education. It states everyone has the right to education. Education has to be free at least in the elementary and fundamental stages. Elementary education shall be compulsory. Education shall be directed to the full development of human personality and to strengthening of respect for human rights and fundamental freedoms. The International Covenant on Economic, Social and Cultural Rights 1966. Article 13 of the Convention states the state president to the present convention recognizes the right of everyone to education. It further states primary education shall be compulsory and available free to all. The Convention on Right of Child 1989. Article 28 recognizes the right to education of the children and prescribes free and compulsory primary education. Passage timeline of RTE Act 2009. With the insertion of Article 21A, education was made a fundamental right and the obligation casted upon the concerned authorities to provide the same by determining adequate law was given a practical form. By enactment of RTE Act in 2009, it took almost 8 years for the bill to pass. The brief timeline of the Act is as follows. In 2003, the first draft of the Right to Education Bill was circulated in public for reviews. After considering the feedback over first draft in 2005, second draft was formulated and again circulated for the feedback of the public. In 2005, the Central Advisory Board of Education drafted the bill and submitted it to Ministry of Human Resource Development. In 2006, the Planning Commission and the Finance Commission rejected the bill for lack of funds to implement the huge education program for a population that stands in millions. The draft bill was also sent to the states, but it was also rejected by the states, citing the same reason. In 2008, after the lapse of 2 years, the Right to Free and a Compulsory Education for Children Bill was introduced in the upper house of the Parliament and was referred to the Department Related Parliamentary Standing Committee of MHRD. On July 20, 2009, the Rajya Sabha passed the bill, and on August 4, 2009, it was passed by the Lok Sabha as well. The bill got assent of the President on August 26, 2009 and was thus notified as an Act. The Act came into force on April 1, 2010. It was the first time in the history of India that a law was brought into force by a speech by the then Prime Minister Manmohan Singh. In his speech, he stated, "We are committed to ensuring that all children, irrespective of gender and social category, have access to education. An education that enables them to acquire the skills, knowledge, values and attitudes necessary to become a responsible and active citizen of India." Basic features of the RTE Act 2009. The objective of the Act is implicit from its title and is enshrined in the preamble of the Act as well. That is to provide free and compulsory education to children between the age group of 6 to 14 years. The basis behind this provision is to achieve the universalization of the elementary education. Section 3 is the gateway of the Act, which states that every child between the age of 6 to 14 years shall have the right to free and compulsory education in a neighborhood school till the completion of his or her elementary education, and that no child shall be liable to pay any kind of fee or charges or expenses which may prevent him or her from pursuing and completing the elementary education. A child above 6 years of age who has not been admitted in any school or though admitted could not complete his or her elementary education, then he or she shall be admitted in a class appropriate to his or her age, provided that where a child is directly admitted in a class appropriate to his or her age, then he or she shall, in order to be at par with others, have a right to receive special training in such a manner and within such a time limit as may be prescribed. It provided further that a child so admitted to elementary education shall be entitled to free education till completion of elementary education even after 14 years. A responsibility has been laid on the appropriate government to establish schools where it is not so established within a time frame of 3 years from the commencement of this Act. It clarifies that the compulsory education means an obligation of the appropriate government to provide the free elementary education and ensure the compulsory admission, attendance and completion of elementary education to every child in the 6 to 14 age group. It also provides for the reservation of 25% seats in all the private and unaided schools for economically weak and disadvantaged community for admission in class. The Act prohibits collection of any capitation fee and subjecting to the child or the parents to any screening procedure while admitting the child. Acting in contravention to this provision has been made punishable offence. No child admitted in a school shall be held back in any class or expelled from school till completion of elementary education. The Act prescribes that school will not give recognition if they do not fulfill the norms and standards set in the schedule. If the existing school do not conform to these standards, the recognition could be withdrawn. The Act also fixes the pupil-teacher ratio to ensure rational deployment of the teachers. The Act also prohibits the teacher from engaging any sort of private tuition or activities. The Act excludes the conducting of any board examination till the completion of elementary education. Each child is to be provided a certificate upon completion of his or her elementary education. It specifies the duty and responsibility of appropriate government, local authorities and parents providing the free and compulsory education and sharing the financial and other responsibility between the central and state government. The financial burden is to be shared between the center and the state government. The Act provides for establishment of school managing committees in all schools except the private and unaided schools, with 75% members being parents and guardians. The main function being the monitoring of the working of the school, preparing the school development plans, etc. Critical analysis of the Act. The RTE Act is one of the historical legislation dealing with one of the social evil that existed in our society at a large scale, that is illiteracy. Though the Act has certain noble intentions of ensuring education to the children at their elementary level, it suffers from various flaws as well. The Act has been criticized on various fronts by prominent personalities and the people working in the field of education. The various issues involved in the Act are discussed hereunder. Public school versus private school. In past few decades, there has been increase in the private school all over the country. These schools are generally equipped with better infrastructure and provides a wide range of extracurricular activity. Such factors are able to attract the pupil towards them even at a high cost. Their parents are willing to spend huge amount of money for admitting their children in such private school. In contrast to this, the government school lack the basic infrastructure. In many schools, the students sit on the floors and there are no separate toilets for the student in the school. The principal does not have a separate office and no separate kitchen to prepare midday meals. There is a lack of facility of drinking water and playground for the children. In such scenario, it is quite evident that parents prefer sending their kids to the private school by spending huge amount rather than to send them to government school that provides free of cost education. As per Annual Status of Education Report 2018, the enrollment in the private school have seen a constant rise year by year. Secondly, exclusion of age group of 0 to 6 years and 14 to 18 years. The Act allows only children between the age of 6 to 14 to get the privileges. It leaves out younger kids, that is between 0 and 6, and the older ones between 14 and 18, despite the fact that India has signed the UN Charter, which states clearly that free education should be made compulsory to all children up to age of 14 years. Critics argue that 0 to 6 years is considered to be the delicate and formative years in children's upbringing, and stopping at 14 means leaving the task halfway, because next 4 years of adolescence are always equally critical in children's maturing process. Education up to age of 14 is not at all sufficient for a person to lead a minimum decent life. Reserving 25% seats in private and unaided school for economically weaker section of society. Under Section 12 Clause 1 of the Act, it has been mandated upon the private and unaided schools to reserve 25% of the seats for the children belonging to economically weaker and disadvantaged section of society who won't be paying any tuition fee for the same. The schools are to be reimbursed by the government on the basis of per child expenditure. No doubt, it is a progressive step and good initiative to remove the economic disparity and to ensure opportunity for all. But there is no mechanism whatsoever for this same. The Act does not lay down any procedure as to how the student will be selected, how the seats are to be filled, what will be the criteria to verify such student, how the schools will be reimbursed by the government, how the whole process will be monitored. All these questions have not been answered in the Act. Further, with such per student expenditure method, there will be inadequate resources flow to private schools. The school will end up charging more from the 75% in order to accommodate those 25%. Moreover, the elite schools have their own culture which suits to children of upper class, and will be economically disadvantaged student fit in these schools or will become a misfit is a serious question to ponder. This provision was challenged in the case of Society of Unaided School of Rajasthan versus Union of India, claiming that it violates the constitutional right to private management to run their institution without governmental interference. The party claimed that providing 25% reservation for children from economically weak section in government and private unaided schools is unconstitutional. On 12th April 2012, a 3-judge bench of Supreme Court delivered its judgment by majority of 2:1. Chief Justice S.H. Kapadia and Justice Swatantra Kumar held that providing such reservation is not unconstitutional, but stated that the Act will not be applicable on unaided private minority schools and boarding schools. Quality of education. The basic object of this Act is to provide quality education to the children at their elementary level so that they are well prepared for the higher studies. It is strange to observe that the Act also recognizes 4 different kinds of school, that is government school, aided government school, specialized school like Kendriya Vidyalaya, Sainik school, etc. and the unaided private schools. In such a scenario, the quality of education is going to vary for sure. Further, the continuous and the comprehensive evaluation system works on the basis of paper-pen exams, drawing, and the ability to express or recite orally. Such assessment cannot provide the insight as to whether the child has actually attained the required educational capabilities. Scoring by rote learning can never be the basis of assessing actual competency. Lack of qualified teachers. The teachers are the pillars of the school. The learning depends upon the method of teaching and the skills of the teacher. But it is quite an evident fact in the Indian government schools that most of the teachers are untrained and unqualified as per the norms and standards. If the teacher is not trained, she can't impart quality education. This can be linked to the drop rate of the children as well. The non-availability of the qualified and trained teacher is one of the biggest obstacles in the proper implementation of the Act. Further, there is no denying of the fact that there are still many schools in India that are working on the shoulders of just one teacher for the whole school. Such shortage of qualified teachers is also a big hurdle in imparting quality education. School management committees. As per the provisions of the Act, school management committees are to be set up for monitoring the working of the schools, recommending the development plans, etc. The composition calls out for 75% representation by the parents of the student, but there is hardly any representation of the parent member in the school management board in most schools in our country. This is an issue of concern and effort should be made to increase parent participation in school management and administration. Prevalence of private tutoring. Although the Act provides the engagement of teachers in private tutoring, it is widespread. Students, whether enrolled in private or public schools, are also attending private tuition as well. The influence of additional inputs in form of tuition on children's ability to read or to do arithmetic is clear. Whether enrolled in government schools or in private schools, children receiving this additional support have better learning outcome than those who do not. There are few suggestions. Following are some of the suggestions for the effective implementation of the Act. The age group of 0 to 6 years and 14 to 18 years should be included in the ambit of the Act. The most well-being legislation may fail owing to lack of awareness at the grassroots levels. It is very important for the authority to aware the public about 25% reservation, the role of school management, committees and other rights created by the law. It can be done by launching mass campaigns and with the help of NGOs. There is a great need to improve the infrastructure of the government schools. As per the ASCR 2018, there is a significant improvement in the provision of facilities and infrastructure at government rural schools. Nationally, substantial improvements are visible over the 8-year period of the commencement of the Act in the availability of many school facilities mandated by RTE. The fraction of schools with usable girls' toilet doubled, reaching 66.4% in 2018. The proportion of schools with boundary walls increased by 13.4 percentage points, standing at 64.4% in 2018. The percentage of schools with a kitchen shed increased from 82.1% to 91%, and the proportion of schools with books other than textbooks available increased from 62.6% to 74.2% over the same periods. Effort should be made to further increase the rates of improvement. Quality education is the basis of RTE and failure to comply with it is a serious concern. Effort should be made to ensure that apart from the inputs, that outputs of the learning process are improved. Qualified and well-trained teachers should be employed in such schools. For ensuring proper teacher-pupil ratio in schools, the government need to recruit teachers on the mass scale, and Ministry of Human Resource Development should ensure training in the form of in-services and pre-services training is given that focuses on training teachers on understanding learning outcomes and competency-based assessment. The financial challenges faced in the implementation of the Act should be looked into by the authorities. There should be a balancing of funds between the center and the state, and the allocation should be adequate and transparent. Keeping in mind the need to improve the infrastructure, the allocation need to be increased. The religious minority schools like madrasas and missionary schools should be brought under the ambit of RTE. It has questioned the quality of education in the madrasas and said that around 2 crore children studying in them are as good as out-of-school kids. These madrasas only impart religious education and are mostly attended by kids from the deprived sections. They are the ones who need quality education the most. In contrast, the missionary schools follow broad-based syllabus like those in the normal schools and have become elitist. However, both are out of the ambit of RTE Act. There should be a bridge between Article 21A, which provides the right of children to free and compulsory education, and Article 30 of the Constitution, which deals with minority education. Education is one of the most important aspects in one's life. Educated people become the asset of the nation who not only work for their individual progress, rather they contribute in the overall development of the nation. The aim in which RTE was enacted needs to be fulfilled to the core, and for this, not only the central and state government but the nation as a whole should take responsibility. Community participation and support can make marked difference in achieving this goal. Effort should be focused on qualitative improvement of the whole program. It is now time to take the next step in fulfilling the fundamental promise to Indian children that they will get an education and not just access to school. Conclusion. At the concluding remark, it can be said that RTE Act is an excellent initiative on the part of the lawmakers, but remembering that it is easier to take a horse to water. The Act will have more teeth if the grey areas in the legislation are effectively addressed by the legislature. Despite the flaws in the RTE Act, if the Act properly implemented, most of the sacrosanct goal of the RTE can be achieved. The Act is excessively input focused rather than outcome oriented. Even though better school facilities, books, uniform and better qualified teachers are important, but their significance in the Act has been overestimated. In order to meet the challenges and surmount the hurdles that stand in the way of implementing Right to Education Act, it is needful to concentrate all efforts with full dedication and commitment. Thank you and have a nice day.